Good morning, everybody. Happy New Year. And thank you for coming out the day after the very long vacation, or at least it was a vacation for some of us, to this very, very exciting conference. So I want to thank a couple people and then talk a little bit about how the day is going to go and how this whole topic is going to go beyond this day, because I think that's really important. Because I go to many conferences over the years, and basically they end when the conference ends and everybody says their goodbye, but that's not what we have in mind for this particular conference. And we're going to be asking all of you and all of your colleagues in communications policy and beyond to be the participants. So first and foremost, at the risk of repeating some of what Phil has said, I want to thank Jenny Toomey and the Ford Foundation for making this possible. Many moons ago, I actually started the portfolio that Jenny now oversees, and I think she is going to take it to amazing heights, and you're going to see some very serious changes in the public interest community in Washington, D.C. and elsewhere, including at Public Knowledge, our organization. I want to thank Phil. He's a longtime friend and able colleague, and also his colleagues, Jonathan Sallet and Pierre DeVries, his staff, Carrie Bedanis, Anna Nochese, I know I'm screwing all these names up, and my staff, particularly Whitney Tompkins, who really worked very hard over the holidays to get this in order. So as I said before, we have an exciting conference. It's not going to be talking heads. Phil and I are going to moderate, very fast-moving panels with a lot of questions. And then we're going to close out the day after. We're going to start with a panel that talks about the future, because we want to start on a positive note and not a negative note. Then we're going to talk about the historical context, and then we're going to have two former FCC chairs, Bill Kennard and Reed Hunt, talk about their prescription for fixing the FCC and take a lot of Q&A. And as I said before, the conference doesn't end then. Later today, we will be launching a website, www.fcc-reform.org, which will have Phil's final paper, as well as all the response papers that you see abstracted in the handouts that you were given today. And what we're going to be asking for are your ideas. We're going to be asking for not only response to Phil's paper and the other papers that have been submitted, but we want you to feel as if you're directly talking to the new FCC chair, and we will deliver these comments to the FCC chair as to how to fix the agency. So we really invite your participation. We'll be sending out an email to all of you here who signed up and to others asking you to participate. So in the spirit of the new administration, which has said they want the public's response, they want the public to participate in policy making and in figuring out ways to fix government, we want you as part of that as well. So with that, I want to thank you for coming. And should we just launch into the first panel? Great. So the first panel is called The Future of the FCC as an Institution. I said before, we want to start on a positive note and talk about where we go from here. Given that there's a general agreement that the FCC is a broken institution, certainly at least the House Democrats felt that way when they issued a report condemning some of the practices of the current chairman. And as Phil said before, this debate's been going on for nearly 50 years. So the question, again, as Phil said, is no longer should we fix the FCC, but how do we fix it? So let me briefly just go down the list of who's here. You have full bios in your packets, so I won't belabor the point. But to my far left is Mike Marcus, who was at the FCC for 25 years. He's an electrical engineer, and now he is the director of Marcus Spectrum Solutions, LLC. One of the interesting things about Mark, he is one of the fathers of Wi-Fi. So that's really very, very cool. To his right is Pierre DeVries, who's a Silicon Flatiron Senior Adjunct Fellow, and he was a very long-term employee of Microsoft. To his right is Jonathan Sallet, who's a partner with the Glover Park Group, also affiliated with the Silicon Flatirons Group. And Jonathan was an official in the Clinton administration and had direct contact to advise then Vice President Gore about telecommunications. We all know Phil. To Phil's right is Jessica Rosenworcel, who is a Senior Communications Counsel for the Senate Commerce Committee. She has worked at the FCC in many different capacities. She's one of the smartest people in Washington, in my opinion. And she worked for Commissioner Copps, worked for several bureaus, and I'm really looking forward to hearing what she has to say today. And to her far right is my longtime friend and public interest colleague, Mark Cooper, who is the Director of Research for Consumer Federation of America. Mark is a true hybrid scholar and public interest advocate, and I know he's got some very provocative ideas about how to fix the FCC. So why don't we begin? And this is going to be a question for everybody, and we'll just sort of go down the line. We'll start with Mike Marcus and go down the line. Please, no more than 2 minutes. So we had an interesting Christmas Eve gift, some of you may have seen. Larry Lessig wrote an article in Newsweek called Reboot the FCC. I understand that was not the original title, but I'm not going to say what the original title was. And he said that it is time to dismantle the FCC and replace it with an innovation EPA, or IEPA, under the control of one administrator. And his premise was that the FCC is hopelessly captured by industry interests and is unable to be reformed. So my question to you is, do you agree with all or part of his premise? And if you don't, what are your top 3 prescriptions, or if you've got less than 3, that's fine, for fixing the agency? So let's start with Mike Marcus.
You know, I read the Lessig paper, and one thing I have to say I agree with it is that the importance of the FCC is not just the communications industry and the K Street lawyers. The importance of the FCC is the whole economy and for economic growth, because communications is a catalyst for all sorts of other industries other than the people who send lobbyists to FCC, and FCC doesn't realize that. I disagree with him on throwing it out in a single administrator is better, and if you're concerned about that, go look at the recent record of the Consumer Product Safety Commission and the Occupational Safety and Health Administration, 2 somewhat parallel agencies, one of which is a commission, one of which is an administrator. In the hands of bad appointees, they both screwed up for the past 8 years. So simply changing the form of the commission to put one person in charge, if you get someone who's like the person running OSHA or the person running EPA, it's not going to be any better. The important thing is to have people in charge who are good and to have oversight. And basically during the past 8 years, oversight has disappeared, both congressional oversight and, as I say in my paper, the FCC Inspector General has been woefully ineffective during the past 8 years. So I think one final thing I would add is my highest priority is to rewrite Section 7 of the Communications Act to make Congress's guidance on innovation clear and workable. Section 7 was a good idea, but it's not workable, and FCC has ignored it for the 20 years since it was written.
Could you say a little bit more about Section 7, exactly what it says?
Section 7 was an attempt in the early 80s to say the FCC had to act on innovative technologies within 1 year. And that's basically all it says. And it really is impractical in the 50 or so words in Section 7 for the FCC to do that, because most of these technologies involve multiple questions. But I think a scheme to Congress's intent that innovation is important and the deadline should be established. There's another section of the Act that I keep forget the number, dealing with forbearance, which also has deadlines, and that hasn't been too workable either. So I think Congress has to establish clear guidance on innovation, but a workable scheme, not just a naive scheme as we have in Section 7.
Pierre?
Thanks, Gigi. Professor Lessig's paper is very interesting when he talks about industry capture of the Commission. I visit here from the other Washington. But as a visitor, when somebody says there's industry capture of an agency, I go, yeah. So yes, of course there's industry capture. It's not always dramatic. I was very surprised, in fact, when one looks at what happened with the white space proceeding, where if I had been a betting person up front and I'd said, well, there's this ragtag bunch of high-tech industry people going up against the broadcasters, who would I have put my money on? I probably wouldn't have put my money on the high-tech industry. So far, they've done quite well. I think Professor Lessig's proposal is one end of a spectrum that I've seen in the comments that other people have made, that you'll read about in the abstracts and hear about today. At the one end, there's throw it all out, start again from scratch. That requires a huge amount of new legislation, which takes, again, I come from the other Washington, but that takes essentially forever, plus or minus 10 years. On the other end, it's a question of just pick the right person. Commissioner Johnson's comment about the qualities. So if you put the right person in place, that's the big part of the battle. There is a spot in the middle which is where I'm quite interested, which is changing the organization of the FCC to reflect what it is responsible for. I think one of the big changes that we've all heard about is, boy, you know, the internet's come along. Why has that been a big change? It's been a big change because the bureaus reflect the industrial organization of 20th century telecoms and broadcasting. And technology changes. What doesn't change, I would submit, are the policy, the social mandates, the public policy obligations that the FCC has to deliver. And I think it would be a much more stable and long-term structure for the FCC to be organized not by industry silos, but by these responsibilities. And I think of there being 4 of them. Professor Lessig focused on one, which is markets and competition. So that's one mandate. Then there are 3 others. There's public safety, consumer protection, and culture and values. Now, all 3, and in fact all 4 of those, cross all the different silos. And if the agency were organized according to those mandates, a lot of the problems we see now in terms of industry capture would be diminished because industries wouldn't be able to capture a bureau. They'd have to deal with all the departments that impinge on their products.
Jonathan, before we get to you, we do have people passing out cards. We're going to spend the last 20 minutes of the session for a Q&A. So if anybody wants a card, my colleagues will be passing them out. And Art Brodsky, Art, where are you? Will be collecting them and sorting them out for me to ask. Okay, let's go on to Jonathan.
Professor Lessig is exactly right to focus our attention on innovation. Innovation is the big driver of economic growth. And indeed, given the depth of the crisis we face, we need not only short-term solutions, but we need to take the steps as a nation to make sure innovation flourishes. But having said that, innovation is a much bigger policy than even the jurisdiction of the FCC in its most expansive mode, right? Innovation is globalization and trade, economic development, education, R&D, competition, and antitrust policy, among many others. So it seems to me that the focus should be on how the FCC as an institution can make innovation an important output of its own actions. And I think there are 3 things that it can do. One is, I think it needs to think about processes that confer upon it political legitimacy. In other words, it's not just enough to make a deal, and it's not even enough to get a ruling that can survive appellate court review. We really need an FCC that's committed to finding facts, transparent processes, applying principles in a fashion that leads people to believe, whether they like the outcome or not, that there's been a fair process that has given everyone an opportunity to be heard. That, as Phil's papers details, is not what's always happened, and that's the first step. The second step is we need an FCC that consciously wants to learn. We don't often think about governmental agencies in terms of learning. We think about them regulating or governing or overseeing. But in a time of technological change as swift as what we're seeing now, and in a time of such great uncertainty about the future, we need a government agency that wants to learn, because no decision it makes today will automatically be the right decision for tomorrow or the day after, unless the agency is always thinking about how to do its job better. The third thing it needs to do is it needs to not only inspire others to innovate, it needs to innovate itself. Think of the way traditional rulemaking work. We take some moment in time, we say, here's the rule, it's pretty rigid, and it lasts forever. And nobody comes back and says, well, have circumstances changed? Does it still make sense? This is not a good approach for the 21st century. And so in the little paper I've contributed, I've gone back to a lecture that law students remember, Oliver Wendell Holmes in the 1880s, talking about the common law as a way to produce new products at every stage of legal development. The FCC ought to think about that as well, because the time for that kind of common law reasoning has returned and can provide a way to be both principled and proactive and innovative.
So let me take the 2 points first I agree with most with Larry Lessig, and the 2 that I would disagree with most. Like others have said, I do think innovation matters and is fundamental in our internet economy, in the information industries. what is important, though, to ask is how do the innovators get the encouragement and get the sense of awareness of what the rules are so they can succeed? And the FCC was created actually for a very different world, where there weren't innovators, there weren't outside entrants, there were a set of regulated either monopolies or oligopolies. And its structure hasn't changed over the ensuing course of history. In 1996, Congress did a lot to change the scope of the FCC's focus, its mandate, but not its institutional structure, not its strategies. And that is problematic because in some sense it still has its culture of political dealing and not a what you might call rule of law culture, which is more transparent, more predictable, and for innovators who aren't inside the political process, don't have high-priced legal talent and lobbies to go to, that leaves them at a huge disadvantage. And I want to commend to you Mike Marks's paper on that very point. So that gets to the question then, what do you do about it? And Lessig's suggestion that a commission form of governance is inherently flawed, I actually don't accept that proposition, and there are a couple of things I would point to. First, during the last several years, the Federal Trade Commission has been much more effective in terms of enforcing antitrust laws by most accounts than the Antitrust Division. As a former alum of the Antitrust Division, that's a hard pill for me to swallow, but nonetheless, I can't reject that argument. Secondly, if you imagined a Federal Communications Commission where it only had one member, an administrator, and that administrator was Kevin Martin, we'd have a different set of results than one where Kevin Martin gets, in some cases, outvoted 4-1 on his own commission. So there's a set of checks and balances in a commission form of governance that I believe can be consistent with the rule of law culture. The challenge is developing the institutions, developing the habits, and getting the right personnel. And I then have to reject Lessig's other premise, which is you can't change DNA. On his account, the commission is subject to Shakespeare's, famous quote, "The past is prologue. It's condemned to repeat the sins of the past." I'm too much of an optimist to accept that point, and I also am too much of a realist to overlook the fact that rebuilding an agency from scratch is a lot of difficult work and not one that I would necessarily wish upon people to have to go through.
Jessica.
Well, it's fair to say that during the 110th Congress, no member of the United States Senate Commerce Committee introduced a bill to dismantle the FCC and replace it with the innovation EPA that Professor Lessig describes. Nonetheless, he has diagnosed a very real problem, which is that regulators look towards the past. They don't think about fostering innovation. They are better at creating stability than they are at creating an environment that develops innovation and lets it flourish. They are much better at representing the interests of those who are in the policymaking present. And if you believe that in this generation the communications economy is going to drive innovation and that in fact it's going to play a significant role in the development of our democracy, and that's a real problem because you're going to need a regulator that keeps an eye on innovation and actually aggressively puts it into its policymaking efforts. As for reforming the agency, I think it is a question of legitimacy. And as Phil was mentioning, the agency grew up in a different day and age. It historically doled out licenses and managed communications monopolies. Obviously, we have a dizzying array of new technologies before us right now. But the question, I think, is how does the agency in this environment acquire its legitimacy? I think there are three ways. First, it can act as a straightforward implementer of the wishes of Congress when Congress passes laws. Second, it can be a storehouse of expertise and therefore a neutral fact finder that resolves disputes. And third, and most importantly, it can be accountable to the American public. And on all three accounts, I think we've had a troubling recent past at the agency, and I think those are three areas that are going to require improvement as we reorient the agency in the next administration.
Mark?
Thanks, Gigi. If you have a 50-year problem, there's probably a lot of causes. And so when Phil says we've had this 50-year problem, you need to look at the causes of the problem. And frankly, when I took a look at his paper, and I had mentioned this to him and Lessig's piece, I realized that legislation is not the solution to any of the problems that the agency has. And so I'll give you 5 problems that I see out there. First of all, the agency is inherently political because the functions it oversees are political, but they're really important. The public interest oversight over the electronic mass media and the means of communication are in fact very important. I believe they should continue to be executed, and in fact they're inherently political, and they'll always be political because they are the lifeblood of politics in our society. Second of all, I read Phil's paper and I said, if the agency can get away with all this crap and not be subject to immediate and certain reversal by the courts, then there's something wrong with the Administrative Procedures Act. Because I ought to be able to get relief from these kinds of shenanigans, and the law just can't be working. Third, the organic statute is horribly ambiguous. Phil says they did something, and the answer is mostly what they did was punt to the FCC all the decisions that should have been made at Congress. And so what we now have is the agency making decisions that are way above its pay grade, and that pisses everybody off. They shouldn't be making the kinds of decisions about the nature of democracy that they're making. The Congress should have done that. The institutional structure is absolutely flawed. It's top-heavy. It's dominated by a chairman. And of course, the chairman in the past have been swung from the ideological, egomaniacal, dictatorial, and inept. And you can decide which categories the 2 chairmen that are going to speak to you later today fit. I won't get in trouble to do that. So what do we do about it? Well, I'm a veteran of 5 transitions from the outside, public interest guy, have tried to advise people. I think there are 4 things the agency has to do. They have to restore procedural fairness, act with administrative effectiveness, provide substantive efficacy, and promote the public interest. I've written all that down in a paper, and I've made a New Year's resolution. I will start every speech, every conference, with the observation that the 30-year experiment we have had in market fundamentalism has collapsed. Let us be clear. Famous line about John Lord Maynard Keynes looked out the window at the start of the Depression and said, "Something is wrong. We have to fix this." The theoretical economists simply don't understand what's happening. We are at that moment here, and we need to reframe this debate in which we recognize, and something that public interest have always believed, that the pursuit of private profit is not always synonymous with the public good. That's not a radical statement. The really radical statement recently came from Alan Greenspan, who in congressional testimony said that the pursuit of private profit is not always even synonymous with the private good. And these were banks. And if the banks can't protect private interest, you can imagine how poorly the public interest fares when we don't have good public interest oversight.
Folks, if in the back, there are seats up front, so if you don't mind being closer to my face, come on and sit up here. So we're hearing that the current problems with the FCC are, structural. They involve a organic statute that isn't clear enough, or an organic statute that isn't implemented properly. We're hearing the Administrative Procedure Act is a problem. Well, so there's a lot of things going on, but maybe it's just possible that the FCC, we're asking too much of the FCC, and we should be seeking a greater role for Congress, lesser role for Congress. Should we be looking to the executive branch? Now, there's a lot of buzz in the blogosphere and elsewhere about what the role of the chief technology officer should be. So should they have more of the policy-making burden on them? I mean, how should the different branches share policy-making power, if at all? So why don't I want to start with Jessica, since she's the Hill person, and see how she would answer that. I mean, some would say, it's interesting, Henry Geller's paper, I think Henry can correct me if I'm wrong, basically said that Congress had too much of a role and that the FCC should be more independent of Congress. Others have complained that congressional oversight is too lax. So, where should the different branches be playing here?
Oh, those are all good questions, Gigi. Congress can and should do more. Like I was saying earlier, the agency grew up in a different day and time. It was small and it oversaw monopolies. We have technology moving at an extraordinarily fast clip. It's trite to say, but it's true. So the challenge for Congress is to both oversee the agency and also update the laws. Now, with respect to the latter, that's especially difficult. Congress, it's no secret to say, doesn't move all that speedily. And Congress also should have some hubris in looking forward to the future and understanding today that we can't quite dictate in the law where technology will take us tomorrow. But under all circumstances, I do think that in the 111th Congress, you will see more oversight of the FCC as well as other comparable regulatory agencies.
Does anybody else want to answer that question? I'm particularly curious about what people think about what the role of CTO should be. Yeah, Mike.
While we've been talking about FCC, let me point out that on the spectrum side of the FCC, a parallel part of the problem is NTIA, which is a single administrator and has been hopelessly ineffective too.
That's another conference next week.
But let me also point out, in Canada, the equivalent of the FCC is 2 agencies. And I sometimes am an admirer of the Canadian function in that the most political functions of FCC, broadcast, ownership, and content, are in a very political agency, which is a commission. And most of the technocratic functions of the Canadian counterpart are in a single administrator agency, part of Industry Canada, Cabinet Ministry. So if those of you who like Lessig's approach, there are some compromises a la the Canadian model, which I have favored for many years.
So I have to say, and I have a great respect for Mike, I do not think that is a good idea to pursue. With technological convergence, I don't think that separation today makes any sense. A couple levels. One is spectrum can be used for broadcasting, can be used for wireless. You need the same agency to be able to make those judgments. We have a challenge, you noted, with NTIA. This challenge, broadcasting, would yet make another agency with that. Not to mention, we have over-the-top video programming. That's going to make broadcasting as a standalone service even more anachronistic than it already is with cable and satellite. So I think to the extent that other model you mentioned ever had any claim to be serious consideration, I don't think it does in today's economy. I also think that part of the idea about how to slice and dice the structure, although you're getting at a core problem, whatever structure you choose, you have to still ask the question, how does that entity operate? And that's the real problems here. Mark and I had a good discussion about people and law versus culture. It's really all those things. And it's not easy to change culture, and to change habits. They die hard. A lot of people around the FCC have certain expectations about how it's going to operate, how it does operate. You've got to change all that. You need a shock to the system. And so here's where the executive branch and I think Congress can play a key role. You've got to have a great shock to the system. Now, Mark says one shock is the market fundamentalist idea doesn't work. I don't think that's enough of a shock per se. I think you need a shock in the sense that we're losing innovation, we're losing consumer value because the FCC, in some sense, is more at stalling progress and regularity and less about trying to give rules of law and opportunities for people to produce real consumer gains. And to change that around, you've got to change, I think, the way the agency operates. And I would commend Jonathan's paper as well. The idea of being fact-driven and transparent is a very different way to do business than the way the FCC has done business. And frankly, I think one thing that has to start happening is adjudication as a tool the agency has never really used, at least not since way back when. And that means you actually have proceedings where you have cross-examination, which is something that doesn't happen at the FCC today. I've heard from people who came from state commissions to the FCC, they were shocked that the FCC didn't actually have anything like adjudication. The FERC does have that, the FTC does have that, the FCC can have that as well.
Jonathan?
Yeah, I think we've heard a really good answer, so let me just say what I think I've heard in the last couple of minutes, because I think it answers your question, Gigi. The first is, the CTO, the president-elect, the White House, the economic team, all have to focus on how to spur innovation. There's no question about that. It's a great national challenge at the moment. We have to restore U.S. leadership in innovation to the extent it's been lost. That means for the FCC, it ought to be rethinking everything it does in terms of what the impact on innovation ecosystems are. Secondly, I think what Mark said is fundamentally important. It may be that historians, looking back at 2008 from a couple of decades vantage point will think that Alan Greenspan uttered the single most important words of the year when he said what Mark quoted and when he said his, quote, intellectual edifice had collapsed. The FCC ought to be asking, what can we learn about that collapse in the financial markets that tells us about the nature of risk, the nature of investment, and the nature of innovation in the sectors that it has oversight responsibility for? Something significant has happened, and the FCC ought to focus on what the lessons of that are. And then thirdly, on the question of congressional role, my sense, I've never worked on the Hill, but my sense is that Congress abhors a political vacuum, and that when the FCC fails, the natural and correct inclination of Congress is to get very heavily involved. But that, if the FCC set itself straight, if it followed real fair processes, if it grounded decisions on facts, then Congress could set the larger principles and let them evolve and grow under the leadership of a new FCC.
I want to, yeah, go ahead, Mark.
The role of Congress, it's interesting. The first time I testified on the Telecom Act of 1996 was 1984. It took them 12 years to write a horrible law. So I'm not holding my breath for that. But there is a role, I think, for Congress. And now I want to get into the accomplishing, because Phil and I have had this conversation. I say we need law, and he says we need culture. And it turns out they're both necessary, but neither is sufficient. And how do I change the behavior at the FCC? And here I think there's a role for Congress. And that is in reaching into the agency. What I need at the agency is I need a much better balance between the chairman and the other commissioners. It's horribly top-heavy, and that doesn't create professionalism or collegiality. Second of all, I need independent bureaus, and we can define them however we want. But I need informational bureaus in the agency that are allowed to do their job. They are not, they have not been under both Democrat and Republican. They are tools of the chairman to reach the conclusion that in which he believes. So how do I create these independent agencies as sources of information? The Energy Information Administration and the Department of Energy, right? Which I hate, but actually it's well respected. I don't like where they conclude, but I can't touch them in terms of their integrity. One of the key points may well be that the members of Congress who have oversight, since I know they'll never legislate anything good, can be available to those agencies to create that independence. To have the bureau heads come up there and say, here's what we really think. And the chairman knows that if he fires that guy, the chairman is going to be in serious trouble. So we have to create a balance between the commissioners so that the other commissioners don't have access to the agencies. They don't have access to the resources. It's completely unbalanced, and we need to create those sources of information as independent. With respect to adjudication, it's absolutely the case. The filing of pieces of paper that are not subject to cross-examination is a waste of time. Over the last 4 or 5 years, we've managed to create a sense of adjudication in the media ownership space. For the first time ever, the agency put out third-party papers for peer review. They botched the process, I understand, but it was a tremendous change in the way they do their business. And so we need to get as close to absolute raise your right hand and tell the truth adjudication as we possibly can. It takes a long time, but it actually tends to give us a better glimpse of what might be, quote, the truth.
If I could jump back in here, Gigi, one of the quick thing the White House can do. The problem is that independent agency has to have some ability to act on its own sort of course without the White House directing it. So the White House's role is not what it is, let's say, for the EPA. However, it can play a key role in helping to nudge and embarrass the agency, and I wouldn't underestimate the value of that. Let's say, for example, the lack of strategic planning. The FCC's current strategic planning on its website is a joke. Mike Marcus highlights it. You've got a certain number of goals on the website. They don't change, and they haven't changed over the last who knows how many years, 5, 6, 7 years. That says a lot. when the White House did have an Office of Telecommunications Policy, Henry will remember Clay Whitehead, who passed away recently, it engaged in serious thinking and strategic planning, which helped, among other things, spur the open skies policy, competitions in satellite. That has brought enormous innovation and consumer benefits. That came result of strategic planning and initiative, which the White House helped spur to embarrass the FCC to change its policies.
Pierre?
For me, an interesting question to go back to this question of the financial collapse and what can we learn from that. I think that there are some interesting lessons. I think the lesson is more a reminder that we are in a complex system that has collapses. There are booms and busts. I don't think there's a way to stop booms and busts from happening. We will see it in the communication space. We will see it again in the financial space. The real question is, as managers in Congress, in agencies, everywhere, how do you manage a system like this that has booms and busts? And I think that traditionally, the agency, the FCC, has thought about what it manages the way a farmer thinks about crops. You know, I've got corn, I've got soybeans, I've got cotton, whatever. They're all distinct. I can manage them. Yes, there are all sorts of complicated things about pests and varieties and so on, but they're relatively predictable. The reality is that it's that the internet has brought us to a place, and the acceleration of global business has brought us to a place where it's much more like somebody who's responsible for the national park system trying to manage fire. You don't have control over the inputs. You don't have control over the outputs. You know there are going to be fires. The question is, how can you minimize the damage and maximize the innovation that happens when the fire sweeps through, burns everything down, all the new stuff starts up? So I think the medium-term thing that not only the FCC but also Congress has to deal with is we are living in a qualitatively new setup where the world is complex. It's not just complicated. And how do we deal with that?
I want to switch gears a little bit and get back to the personnel question, because as you'll see in Phil's paper, and if you read Nick Johnson's paper and Henry Geller's paper, which is not available online but will be on the website, we'll have to scan that paper, they talk about the personnel problem and the problem of industry capture, and the revolving door. So either people come from industry, go into government and leave, or people that might not have a history in the communications industries might be looking for a job when they get out. In fact, Henry's paper suggests that commissioners be given a 15-year non-renewable term and that they be barred for the following 10 years from working in the communications industry. Now, Henry, I don't know how you would actually enforce that, but so there clearly is a concern that that the right personnel are not being put in. You know, people that might have a history in the communications field get stopped by industry players. So how do we fix that? Or is it necessary to be fixed? If it is, how do we fix it? President Clinton had suggested a 5-year revolving door policy where you couldn't lobby the agency after 5 years, but he quickly repealed that. So does anybody want to address that industry capture question? Mike.
Yeah, I said a few things in my comments about that. If we follow past precedent, in the next month or so, most of the bureau chiefs of the FCC will be fired or rotated. That's a bad idea. I mean, maybe the current ones need to be fired, but in other regulatory agencies and towns, the top civil service managers aren't fired with the change of administrations. And the commission ought to think of a way of evolving to a set of senior managers, but the senior managers have to realize that, like British civil servants, they should become apolitical. And many of the senior managers at FCC, even the ones who are career civil servants, become political. So I think that's a very important thing to do, whether we need a 5-year period, some increase like that would be. But the FCC does not really develop its managers. And another thing I noticed, I was on a rotation from the FCC to the Japanese counterpart. In the Japanese counterpart of the FCC, people rotate from bureau to bureau, the equivalent from bureau to bureau, and frankly, that decreases capture, because if someone has worked with the land mobile industry, with the satellite industry, and with the cellular, with the broadcast industry, they're familiar with all the industries, and they tend to have less of a preference. In the FCC, there's virtually no rotation. And in the days of convergence, It means that most of the policymakers have never dealt with more than one industry, so therefore they favor the industry that they've dealt with.
That's a really interesting point. Mark?
Well, if you looked at the New York Times yesterday, there was on the back of the Outlook section, there was a 6,000-word article on how to deal with the financial meltdown. And one of the central propositions there was the problem of the revolving door. And if you think you've got a bad revolving door at the FCC, just go over and look at the SEC. And the interesting point about that article was, and it underscores how important the silence period is, right? Because you can't get enforcement people who know that they're about to go out into industry and make big bucks to enforce the law. That's the simple proposition, is that they simply would not look at people's balance sheets and put them out of business when those were the people they hoped to work for. And so the period in which you are not allowed to work in the industry, and let's be clear, we do that all the time as a court conclusion to a scandal, right? We put some guy out of the industry for a half a decade and say, you can't work, or maybe for life, you can't work in this industry. And so the key to solving that problem is to simply say, if you've been a staffer or a commissioner here, you can't go to work in that industry for X number of years. Now, of course, that interdicts the marketplace. Too bad. The public interest here needs to be protected, and the only way to prevent the abuse of the public interest is to put that ban in place. Now, that also means we will have to have a civil service that's meaningful and respected in America. We don't have that, huh? We spent 30 years talking about how poor and asinine government is. Nobody wants to work in the government anymore to protect the public interest. We have to change that. That's the frame we have to change. Turns out we have a new administration that has actually said that's the frame we want to change. But the key has to be to sever that link between being in the agency and hoping you're going to get a job next month, next year, in the industry. You can't regulate it if that's in the back of your mind.
Jonathan, I know you had something you wanted to say.
Well, I just want to add to it. You know, if you read Phil's paper, as I hope everybody here does, and Chairman Dingell's report last month, you think that the problem isn't just who's in the agency, but how those people are treated. In other words, it's very important that people who get the jobs get an opportunity to work through issues, talk about them honestly, and lead a discussion inside the commission that involves all of the commissioners. Without that, that's sort of the oxygen that keeps the flame burning. Without that kind of process inside the agency, whatever the rules are, however good they are, they won't actually solve the problem, because what we'll still get is stultified and politicized discussion. That when Phil talks about examples of paper flying in the night before on a complicated issue, that's not a way to encourage discussion and debate. And so I just think whatever these personnel issues rules are, processes have to go hand in hand with them.
Anybody else?
Yeah, I'll make one final comment, which builds off what Jonathan just said. If you look at what the FCC has done at its best that is free of industry capture, they've been able to think proactively, set the agenda. So we've talked about Wi-Fi, and Mike deserves a lot of credit there. That was a context where the agency was able to think strategically and out front about what might happen, and they didn't know exactly what it would be, but they knew that unlicensed spectrum could create great things. There was no lobbyist for unlicensed spectrum because the companies didn't exist. Part 68 rules, equipment attachment rules. There wasn't a modem industry then because that didn't exist. But on these occasions, the commission thought ahead of the curve, they thought proactively, and they had independent information, and they weren't, in a sense, captive of the industry's request and purely reactive. And I think that, in some sense, is a more fundamental challenge than the classic industry capture concerns that Mark detailed.
Folks, just before, I didn't know, I wanted to see if Jessica and Pierre have anything to say, but Michael and Art are taking questions and bringing them up to me, so, and we're going to get into the Q&A in just a few minutes. So, Jessica, did you have something you want to add? And then Mark, go ahead. Did you want to say something? Okay.
Let me talk about industry capture as a little bit more than just a personnel issue. When you have the interests of the regulator and the regulated entities so closely intertwined, you have a problem. You have an agency that has lost sight of its mission. And from the perspective of Congress, at least, that mission is for the betterment of the American consumer, the American people, and the American public. So the industry capture question to me is, how do you create an agency that is more accountable to the American public? I think it is useful to consider other organizations around town. For instance, the Department of Transportation has a Bureau of Statistics. That Bureau of Statistics produces data that will tell you for all sorts of flights, if you're taking a trip on an airline carrier, which ones get in on time, which ones do not, which ones do they tend to lose baggage on, which ones do they do not. They also tell you which carriers receive lots of complaints and those who have generally satisfied customers. Now, the FCC collects a lot of data, but I challenge anyone here to go and look up Form 477 for broadband or Form 323 to figure out who owns the media properties in your hometown, much less the ARMIS database. So I think the challenge going forward is to make the agency more accountable to American consumers so that the price of the American public participating is not so high. Imagine an agency where you could look up and compare some information about available broadband plans. Imagine an agency that could tell you, well, in fact, that wireless carrier does or does not have service in the area you travel regularly. Imagine an agency that has information about educational and informational programming pursuant to the Children's Television Act that is actually useful, so you know when you can sit your child in front of the television set comfortably. So I think that that is a quick and direct way to start addressing agency capture. I do think there's a personnel problem, but as Mark said, it is much broader than just the FCC, and it's a problem that is all around Washington and may perhaps be dealt with by some experts at another time.
And Mark, before you answer, I just want to sort of tag on kind of my last question, and then I'll get to the public questions. You know, the issues the FCC deals with are complex, so how do we make the agency more transparent? I think Jessica had some excellent ideas. You know, how do we give the public more of a voice? And do we need to maybe think about changing the Sunshine Act, which says if more than 2 commissioners meet at one time, there has to be a public notice and that sort of thing? This is something that former Commissioner Irvin Duggan used to complain about mercilessly about 10 years ago. So if people might address, you know, what are other things the Commission can do to be more transparent to the public? I think you talk in your paper about fixing the ex parte process, which is completely a joke. And to give the public more of a voice, or to at least require the Commission to listen to the public. So, Mark, go ahead, and if anybody else wants to...
Two quick observations. People talk about spectrum, but frankly, I have come to the conclusion that the single greatest year in regulatory history in the past half-century was 1968. Because in 1968, the FCC made 2 regulatory decisions that were magnificent. Carter phone and the computer inquiries. I mean, that's one of the cornerstones of the internet, and we tend to forget that. How did we get there? See, Phil points out that in the wireless space, it did not look like there were industrial interests that understood what was about to happen to them. Honestly, if the NAB had known what wireless was going to do, they would have killed it back in the 80s, right? So, but in the computer inquiries, and Carter phone, but particularly in the computer inquiries, the essence of the outcome, there were industrial interests who were against you. The incumbent monopolist was dead set against this stuff because AT&T kind of knew way back then. They said, I'm not going to do this stuff, right? They had turned down the opportunity to build a decentralized network. The key to me was that, one, the agency actually accepted the public interest in that proposition as opposite from the interest of a monopolist. And 2, it turns out that all the big corporations who knew they were going to move data were on the other side. So it turns out it was a battle of private interests to push the agency to its outcome. With respect to the transparency stuff, the experience we have had is that, one, ex parte is just horrendous. We play the game too, but I don't have nearly the troops that the industry has. 2, the notices of proposed rulemaking do not rise to the level of a good notice of inquiry at this agency. That's why the courts should absolutely have turned back every one of these rules, because the public was not given proper due process in notification. Those proposed rules are a disgrace, and the courts ought to change that, and everybody in this room ought to try and change that. as part of that process, peer review for research ought to become a standard operating procedure and done correctly. Public hearings, absolutely. Those are the kinds of things that make these guys go out to the countryside and get yelled at for 8 hours. But you know what? There are real people out there who actually care about some of this stuff, and if you give me a chance, I will fill the room so that you remember you do actually work for the public. So those 4 things would change the way the agency does business without any statute, without getting the Congress involved, and the procedural things that the next chairman could do with a flick of his pen.
Quick answers on transparency and public participation, Mike and John.
The current FCC website was designed early in the Chairman Hunt administration. It was a good idea for the early Clinton administration. It's woefully out of date. If you compare it with any other regulatory agency in town, you'll see why it's woefully out of date. And part of this transparency is because you can't find anything on the FCC website, and you can't see even how many of the ex parte filings are one page or out of date. Finally, it's been mentioned the Part 68 rulemaking, the open skies policy, and Wi-Fi. What all 3 of these have in common was the FCC at that time had a budget for outside resources. In the case of Part 68 and open skies, they went to the National Academy of Sciences, got an independent review. They haven't done that in 30 years. In the case of what became Wi-Fi, they had money to go to MITRE Corporation to do a pioneering study. There are some budget problems that get in the way of transparency that have to be resolved.
There is no episode of Law and Order, I mean, we're going on 20 years, right, that doesn't have some lawyer cross-examining some witness. We ought to have as an aspiration for society that the FCC is as good a legal system, at least, as Law and Order. Right? In other words, the basic way of challenging a point of view isn't used when contested facts are at issue at the FCC. I don't mean that everything needs to be a formal adjudication, but where facts make the critical difference in deciding one way or another, we need a way to find them, not for some abstract legal reason, because if we don't know what happened. And if we don't know what happened, we can't ever do a good job.
You want to give a specific example that comes to mind? Okay, go ahead.
So, ex partes have been mentioned. For those who aren't totally inside baseball, that means you have a formal comment period when the debate supposedly happens, and then you have the real sort of action, which happens afterward through these so-called ex parte filings, which means one-off meetings. And there's 2 different types of ex parte problems. The first is literally the ex parte that says a discussion was had on the issues, period. So people who actually get the filing have no idea what was discussed, and it's not part of a meaningful debate. The second problem is, no, a substantive filing is put in, but at the 11th hour by some knowledgeable source, and that helps drive a decision, and that isn't part of a real process. Now, both of those are antithetical to the law and order cross-examination model, and they're antithetical to good public policy making. So that, and I'm not making those 2 up there in my paper, and that's sort of, again, a cultural problem that's allowed to happen. That should be embarrassing, and people should be embarrassed to the extent that that's how law is made.
Okay, I think I want to get to the questions. Here's a real good one. So Mike Marcus invokes a Canadian regulatory approach. Others look to Britain's Ofcom as a different approach to delimiting the scope of the problem. There are many models of operating procedures. What other foreign practices can the FCC learn from? And I'll add to that, not just foreign practices, but just other agencies in the U.S. as well. Mike?
I did some work for the European Commission when I lived in France, and what impressed me about the European Commission regulators is they're much more, the people who regulate communications are not just worried about the T-Mobiles and Nokias of the world. They're worrying about how to move the whole European economy forward. And what I see at the FCC and other U.S. regulators, they're focusing on the health of their particular industry, not its impact on the whole economy. And that's what I think is one of the biggest values of the Lessig paper, pointing out that if the FCC gets its job right, it'll help the whole economy, and FCC doesn't even look at that very much.
Pierre?
Yeah, just the question of points to Ofcom, and I think that reminds me of something which is very useful about Ofcom's approach. In their charter, in their mission, they make very clear who they work for. Their goal is to advance the interests of citizens and consumers of the United Kingdom. And I think, as somebody who visits Washington, this public interest test constantly amazes me, because it essentially means we can do whatever we like and we'll label it public interest. There is no way of testing the public interest that any lawyer has been able to explain to me. So I think that other regulatory agencies, particularly Ofcom here, have pointed the way. Yes, a consumer surplus test is imperfect because it involves economists and simple numbers, but at least it's more objective than the public interest.
Okay, here's a question for Jessica. Will Senate Commerce Chairman Rockefeller pursue legislation this year to reform and fix the FCC? And what FCC-related issues will the new Congress address, and in what order? Small questions. Answer which either one you'd like, in less than 2 minutes.
Well, the new Congress will start tomorrow, so we'll see what's ahead. I can say with some certainty that there are a few things that are on deck early, and I don't think these are really surprises. Nonetheless, I can just say that we will be dealing with confirmations. We'll be dealing, obviously, with the digital television transition, which has occupied a lot of our time during the last year, as we're worried that as many as 21 million households in this country that rely exclusively on over-the-air television may find on the morning of February 18th that they no longer receive a signal. We have concerns that the coupon program that was developed to support the digital television transition and consumers who rely on over-the-air broadcasting is about to be exhausted. We have concerns that consumers don't know precisely what to do with a converter box when they actually get a hold of one. And we have concerns that some consumers who actually dutifully follow all these instructions will find that nonetheless they still don't get a signal because of the digital cliff effect. So that is on tap early. In addition, obviously there's been a lot of discussion about a stimulus package, and so in the Commerce Committee that means broadband stimulus, and we are starting to have a lot of dialogues. If we don't have hearings, given the time frame, we are nonetheless having a lot of discussion about just what we can do to stimulate both the demand and supply side when it comes to broadband in this country.
This is an interesting question. Doesn't the revolving door help cross-pollinate experience so public interest outlook can be exported into companies and real-world experience with how technology and business work can be brought into government? Also, it gives ambitious young professionals the opportunity to serve the public at lower pay. They can earn more, okay? Otherwise, many highly qualified people might opt never to work in government. And that is one of the criticisms of the 5-year plan, is that you'll keep good people who, who eventually want to make a buck, have a family, what have you, keep them out of government. So any response to that? Maybe the revolving door isn't such a bad thing? Go ahead, Mark, and then Mike.
Essentially, what you have to do is balance the problem of conflict of interest with the possibility of expertise. And the simple fact of the matter is that we have learned over and over again across a variety of sectors that a conflict of interest problem is deadly if you let it run wild. And that is what has happened in the financial sector. You can just take a look at it and you can see what has happened. So the incentive to pander to the industry you're supposed to be regulating is just too powerful. And it undercuts the quality of regulation. The solution has been, certainly was in the New Deal, across a variety of industries, to simply ban conflicts of interest. The notion that you can create institutions and structures that allow them to occur and then police them it flies in the face of experience. You can't hire enough accountants and cops to chase a bad conflict of interest problem. So I think the answer then is, one, do a decent period of time to frustrate that conflict. If it's 5 years, no one is going to take a government job if they know that they can't go and get rich in the sector in 5 years. The counterpart to that is we have to enhance the value of public service. We have to pay people well. We have to give them the prestige and honor. We have to stop bad-mouthing them from the White House every time we start a press conference.
Anybody else? Mike?
Let me take one of them.
Okay, wait, let Mike and then Phil, you go ahead.
I agree with that last point, and in my paper I have several ways how the FCC can spend more resources nurturing its staff to ensure a professional staff. But let me point out, you have two knobs where you can control conflict of interest. One is how many years the ban is, and two is the nature of the ban. When I retired from the FCC, I faced a 1-year ban on writing comments to the FCC and signing them myself and physically appearing before the FCC. That's the current practice for senior people at FCC. There are ways one can expand that, decrease that, but a total prohibition that would have prohibited me from working anywhere in the electronics industry for a year would have been a problem, and the question is exactly how you structure it, and that's how you can balance the competing interests here.
So part of the way to respond to the question, too, is do you think the FCC is not an industry-specific regulator, but deals with competition, innovation, consumer protection that happens to be focused on the information and communications technology sector? There are other opportunities for dedicated public servants, whether it goes to other agencies in the government or other private sector nonprofit. And so part of the challenge is a broader conception of how the FCC operates. This gets to Pierre's non-silo approach. And then I think you're not thinking in the same narrow terms that the question was. And that's something the FCC needs to do anyway, and I think in this respect, if it does it, it also then opens up different possibilities for employment as opposed to just looking at this narrow question in the industry or in the regulator.
Let me ask a follow-up question. Is capture really more of a problem than agency intimidation by the D.C. Circuit or Congress? Too often, staff fear reversal and career repercussions rather than hoping for their next job. What can be done to reassure staff they are free to make the right decision?
Well, I think a bigger problem is fear of the staff to say anything. When I was at the Antitrust Division, we went to talk to the FCC for the first time. Some FCC staff then were reluctant to say what they thought. The report by the House Majority staff says that that cultural sort of concern has become a epidemic where there's a climate of fear where people will never say what they think. And so, people may say that the concern is the D.C. Circuit reversing them, but I would just say what Justice Ginsburg said about, deference is you do good work and you get deference. Part of the problem the FCC has right now in the courts is it hasn't done good work. Part of why it hasn't done good work is because it hasn't been, an open discussion of ideas. It's been about trying to get to results where they first figure out the result and then try to basically paper the way there. And that's a dysfunctional culture. And that has to get fixed. And once that's fixed, then the D.C. Circuit problem will take care of itself.
I think designating a court as the home court of an agency is a disaster. It's a terrible mistake, and the media ownership rulemaking is a perfect example, right? We actually escaped the D.C. Circuit because it was not an issue that was designated, and it just so happens that, and everyone thought that they were going to send it back to the D.C. Circuit as the expert court, and they didn't for a simple reason, that no judge in America believes that any other judge in America knows more about the First Amendment than he or she does. So here was a court, every court, and I understand some courts don't want to have the headache of this technical stuff, but the FCC has been captured by the D.C. Circuit, and that's a bad thing. That we ought to get a random set of distributions of courts, and that would liberate the FCC from the tyranny of a set of judges who, have a particular point of view. Fixing the statute would help too. Let's be clear. The statute is just a blank sheet, and so you want to talk about judges, judicial activism. The D.C. Circuit implementing the '96 Act is a perfect case where they're writing the law, but that's only because Congress didn't.
Anybody else responses? Okay, this is a good question as well. No one has yet discussed re-examining the array of functions performed by the FCC, such as oversight of Universal Service Fund, the Telecommunications Relay Service, and other entitlement-like programs. Shouldn't this be part of the reform examination?
I'll say one thing Jessica already said, the digital TV transition. Part of the problem is the FCC has different functions that it's not always well set up to implement. And digital TV is an entirely different sort of enterprise, involves public information and public education, something they have not taken seriously. And so, I think that one thought about, if you want to break out different functions, think about it along functional lines, not along sector lines like, broadcasting. And I think it can do those things better, but it has to self-consciously see itself in that business. And I think part of the problem is they've been kind of, adjuncts that they've kind of said, yeah, I have to worry about this. I don't necessarily have as much of a view, but I will say that part of the problem is they have to own those functions more seriously. And in the public information one, I think that's a big one.
Yeah. Pierre and Mike.
Yeah, just to follow up on Phil's point, yeah, I think it makes a lot of sense to reorganize by function. There are the beginnings of that already in the organization, in that the Bureau of Public Safety and Homeland Security deals with public safety. But if you look at things like markets and competition, that's covered by a whole raft of other bureaus. And I think if there were a functional reorganization where the FCC was organized by markets and competition, public safety, culture and values, and consumer protection, a number of things would happen. You'd get less industry capture because companies would have to deal with all those departments rather than their particular sectoral bureau. But also it would make clearer where there are overlaps with the FTC, for example, or with DOJ, or with other agencies that are responsible for CPB. So once it's clear that there are overlaps, because there are departments that deal with those things, then Congress and, in fact, the chairman can start to decide how they're going to deal with those overlaps. Right now, I think the overlaps are much too hidden and complex to actually resolve.
Pierre, before we go to Mike, could you just give me an example of what kind of decision-making the Markets and Competition Bureau would have, and particularly the culture and values? Yeah. That's the one that kind of makes me a little nervous.
It's funny, you're not an American by any chance, are you? Yeah, well, you know, the markets is, in fact, where a lot of the discussion already happens. So, for example, when Professor Lessig talks about abolish everything and have an innovation EPA, he's really just talking about the market's function, and that's things like managing market failures, dealing with mergers, merger conditions, facilitating market entry, all the stuff around auctions for spectrum, that's all about markets, interconnection, those are all questions about markets and competition. So all those issues, whether they're Wireline Bureau, Wireless Bureau, Media Bureau, they all go into that department. When it comes to culture and values, well, there's, in the US at least, there's a lot of conversation about control of speech. Now, we have in the pack some people suggesting that this should not be a responsibility of the FCC at all. It's a political one, as Mike was talking about. But clearly, there's that issue. There's the whole question about state funding for content production. So the Public Broadcasting 2.0 idea would fit in there. And then also rules on advertising. So those are all culture and values questions that regulators, for example, in Europe, clearly understand that they have. The FCC tries to cover them, but some chairmen more than others. And I think that if we had a Department of Culture and Values, it would call the question. Is this something the FCC should be doing? And if not, who else should do it?
Yeah, can I just say something about the First Amendment interests? Just on Pierre. We talk a lot about the extent to which First Amendment interests ought to indicate outcomes. We don't actually have a very good notion of how that works, right? There's a Turner Broadcast case from the 90s that looks at that. But one of the things about Pierre's proposal that is interesting is it would force us to actually try to focus on and decide the nature and extent to which diversity of speech issues should have decisional significance. And that would be a very useful step forward.
Mike?
My previous remarks about the Canadian situation didn't get rave reviews, although I still think that there's some benefit there and it's not outdated. But let me point out, DTV promotion has been something which I think FCC has done a miserable job at. And one of the reasons is a regulatory commission it's not set up to do that. Universal Service Fund distribution, as opposed to raising the money, it's done an awful job at, because when you're distributing billions of dollars, there's inevitably a lot of exploitation and illegal use of it. A regulatory agency isn't set up to do that either. I frankly wish that all of DTV promotion had been handled on a different agency, possibly NTIA, which would have fit in with the coupon thing, because it is part of a major cabinet level thing which has more checks and balances, for instance an IG that actually works. And also Universal Service Fund distribution as opposed to policy making, perhaps that should be sent off to another agency, because the FCC doesn't really have the oversight to watch out of whether, and that's what the House report said, the FCC has done a poor job on the oversight of how the money was actually spent.
Okay, we've got 5 more minutes. Okay, Cooper, quickly, and then I want to ask my final question.
I would entertain the notion that the agency needs to get back to its genuine public interest obligations. So it may be doing lots of things that do not derive from the fundamentals of, one, promoting and ensuring democratic discourse, which involves both the regulation of broadcast licenses, and as long as a TV license is a powerful electronic voice, that function needs to have public interest oversight. There may be lots of other voices, but make no mistake about it, Barack Obama did not spend $500 million on TV advertising because he's dumb. TV is a powerful economic voice. The license confers a special privilege on the holder, and that is abhorrent to our democracy. And so we have to deal with that, and as long as that's the case, we have to deal with that. On the communication side, the access to the means of communication is, in essence, both a political and an economic right that the agency has to deal with. Whatever you can derive from that, the agency ought to do. Whatever else it's doing that doesn't derive from those things can probably go away. And I think Pierre's culture and values is probably vastly overstated for that function. It's simply because it contains too much of telling people what they should and shouldn't say. We only care about allowing them to say what they want.
That's not totally true. There's the whole children's, television is about, we want more kids programming. There is a concern about, localism. We want more local programming. So it's, I think Jonathan's point is well said. It's kind of been an undercurrent there, but we've not necessarily had a debate and discussion about what kind of programming do we want and how do we get it.
And I've sort of tipped my hand about how far I would like that to go. And there is a difference of opinion in the public interest community. But the essential function here is, freedom of speech. And the Supreme Court has gone beyond that to talk about diversity and the statute, and we've accepted that. But for me, those two central functions of making sure people can speak and making sure people who are conferred this wonderful privilege of having a broadcast license don't abuse that voice are sort of the essence of what the agency should do. So, but clearly the universal service fits in the question of access. Relay fits in the question of access for specific people. And so those are functions that belong in a regulated space, in my opinion.
Do you want to add anything, Jessica? No? Go ahead.
Well, I think both now and for the foreseeable future, you are going to see an FCC that has both economic functions and non-economic functions. That's the way that Congress likes it. Economists might dispute whether that's a good thing or not, but non-economic values like universal service, concern about the television that children watch, making sure that people with disabilities have access to equivalent facilities, those are here to stay. I think the challenge for the agency going forward is to make sure it does a better job at monitoring, implementing policies, updating its policies, and making sure that there's no waste, fraud, and abuse in the process.
Okay, here's my final question. You've all just been named special advisor to the new FCC chair, and you have 1 minute to tell him or her how to fix the agency. Okay, so starting with Mike, let's go down the list, and what will you say to the new chair?
I would say improve the professional staff and listen to them.
Wow, that was done in 10 seconds. That's even better.
I would say throw out the bureaus and reorg according to functional departments.
I would say your job is to listen, to learn, and to lead. That you need to invest the staff with power, you need to make decisions, and you ought to seek the goal of innovation, job creation, economic growth as a critical outcome that the agency is designed to, in fact, produce.
You need to take information analysis and fact gathering very seriously.
Two things. I think it might be time to dispense with ideological approaches and return to a restoration of facts and respect for facts, and some searching about to try to find the best answers wherever we might find them. And then secondly, I think it is important to make the agency accountable directly to the American consumer and not just the industries and people who appear before it.
Four quick things. One, don't complain about the statute you've just sworn to uphold. If you didn't like the statute, you should have run for Congress. We've had commissioners and chairmen who spent a lot of time complaining about the statute. Second of all, do a mix of three things: immediate, important, and symbolic. You got to pick something and do it quickly. You also have to surprise people. So you need to do something that surprises the majority. You need to do something that surprises the minority, because that way they can't take you for granted. So now you've actually shown that you can get stuff done, and two, nobody can take you for granted. Now they have to really take you seriously. And having done that, you have to listen to what people say. Don't give me speeches telling me what you know is the right answer before you've had the proceeding. None of those awful speeches we hear about. You're supposed to be there and say, tell me what the right answer is. That's your job. Symbolic things are really important because people then sense that you know where you're going. And the immediate and the symbolic give you a cocoon in which you can actually get the important stuff done, because people are fed with the immediate goals. They've been gratified with something you did quickly. They've been engaged in the process. The symbolic says, hey, this guy's going in, or gal's going in the right direction, and now we can spend a couple years doing the important stuff.
Well, this was an excellent panel. Please give them a round of applause. That was fantastic. So, two logistical things. The first and most important is I realized I did not mention who I was or what the name of my organization was. So for the TV cameras, my name is Gigi Sohn. I'm the president of Public Knowledge, and we're a public interest organization that works at the intersection of intellectual property and communications policy. And second is we'll take a 15-minute break and come back at 25 till for the historical panel. Thank you.